Welcome to Lunch Time Tidbits with Saprina Allen, the godmother of notes and president of Mainstreet, and your host, yours truly, Joe King, co-founder of Revival Brothers. Before we begin, I wanted to thank our sponsors because without them, none of this would be possible. Our sponsors include Revival Brothers, LOI, the Leaders of Integrity, Prolific Realty, the Ideal Property Analyzer, and the Art of Notes. So if you guys ever have a question about any of these companies or what they do or how they might be able to help you, feel free to reach out to me or Saprina and we can guide you in the right direction. We have received many requests to explain the difference between judicial and non-judicial foreclosures. And because this topic covers quite a bit of information, we wanted to divide it into two parts. So part one today is going to be focused more on the judicial side, and next week we'll focus on the non-judicial side. So with that, I want to introduce to you Saprina Allen, again, president of Mainstreet and a seasoned professional who's directly been involved with many facets of note investing, just about anything you can imagine. And I also want to point out that this is a great opportunity for anybody to ask questions. There's a question link at the bottom of your window that you can click on to ask questions. And then if you want to make comments or chat, you can do that in the chat window as well. So with that, I'm going to give the floor over to you, Saprina.
Good afternoon, you all. Before I start my presentation, I always want to kind of set up how you need to think if you are a note investor or if you're buying. So one of the things when you're looking at a data tape and you see something that's in foreclosure, there needs to be a mental note that you make to yourself that there may be another step that you need to do after you funded your deal. So if a loan is in an active foreclosure with a law firm, you need to make sure you find out who that law firm is and get as much contact information as you can, because you want to do a proper handoff with the law firm. You don't want to end up having to pay for legal fees from the previous owner of the previous note owner, and you don't want the ball to drop because there's things that have to take place because you've actually purchased a loan that's in an active foreclosure, whether it's in a judicial state or a non-judicial state. So what that looks like is once you fund it, you need to call that law firm and tell them that you need to set up an account, you need to sign a letter of engagement, and start the clock ticking in reference to your financial responsibility for legal fees on the day of service transfer. Anything prior to service transfer should technically be the previous owner's responsibility, and it should also state that in your purchase and sale agreement on who's going to be responsible for what costs. Sometimes if that's not clear and it's a little muddy, sometimes the attorneys will stop working the files until their invoices are paid. Mm-hmm. So you need to make sure you work that out in your purchase and sale agreement. That's one thing you need to do. And then you need to kind of see how long has this file been with this law firm? Is it, and why hasn't it moved along, or is it where it should be? So ask some fact-finding questions. When was the file assigned over to your office? Could you give me copies of the title report, any things that's been filed with the court? Request copies of those things, because more than likely in the service transfer, you probably won't get those documents. And then you need to do some more fact-finding things, such as, is this an attorney that somebody is utilizing in our network, in our family? Because sometimes you don't know. There's a few out there right now that when I'm done, I'll never use them again. And I won't publicly talk about who they are, but in a service transfer, what we found is that, they just milk you and milk you and milk you. The other thing is that you need to find out if the loan is actually in an open mediation, because if it's in mediation and you buy it, you're pretty much stuck. So you need to know, when you're thinking about your exit strategies, what the end result's going to be if this file is already in mediation. This is a true story in reference to an investor purchased the note, didn't realize it was in mediation. We're about $12,000 in on legal fees, and they're nowhere near resolution. We just got another continuance until like June because of the coronavirus. But this has been going on for a long time, and you also need to factor that into your costs and your expenses. So I know that was a huge mouthful that I just said in my opening, but these are things that people don't talk about. These are things that you don't know. It's not just understanding the process, the legal process, it's also understanding the process and the steps that you need to take as a note investor to make sure you understand how much money you should set aside, especially you guys that are using your retirement account, because you can't commingle funds, meaning you can't use your personal funds with your retirement funds, depending on what type of retirement account you're using to fund your notes. So that's why I always talk about holding back that 25% of whatever your investment is on the larger scale, but sometimes you need to set back more on the onesie twosie deals. Okay, Joe, I'm sorry, I'm done with my rants.
No, that's perfectly fine. I think that it gives people perspective, actually. So, and I think that when we look at judicial and non-judicial, I think that 25% still stays true, right? We're still looking at holding back money regardless if it's judicial or non-judicial.
That is correct.
Right.
You know, even though we're not talking about, you know, non-judicial states today, right now we're in a case $70,000 in the state of Texas. So we're not going to talk about non-judicial today, but I just kind of want to point out to you guys, those legal fees can still rack up in the non-judicial states.
Right.
And right now you guys are looking at a map. Anything that's in gray is non-judicial, anything that's in blue is judicial. And just so you can kind of see, you know, how the map flows in reference to what that looks like. And it's a quick reference guide that we'll have up on the LOI site, where you can see with just, you know, really a quick look when you're doing your due diligence, if this state is judicial or non-judicial. The other thing that I want to point out to you guys today is that even in non-judicial states, depending on what type of paper that you buy, sometimes you still have to go through the judicial process of foreclosure. So I want you guys to also know that. So a lot of equity lines of credit, if they were an equity line, you still have to go through the judicial process in order to be able to foreclose. So you need to know that as well.
Right. So
you know.
Go ahead. I'm sorry.
Okay, I'm sorry. Go ahead, Joe.
I was just going to say, point out that this is just a judicial slide that gives you the definition. And again, we're going to make these this PowerPoint available to everybody on the LOI site. So feel free to go there and download it once we have the video up. But yeah, this is just an explanation as to what judicial means. And you know, as Saprina said, that there are variations to the process depending on the paper you have. So just keep that in mind. It's not black and white. It's not a judicial state or a non-judicial state. It also has to do with the paper you have.
That is correct. And also, even though we're kind of, I'm jumping ahead, but I also want to make you guys aware that in some states, when you go through a foreclosure process, or if it goes to tax sale, overage doesn't always go back to the lender. So you need to also know that if you are letting something go to tax sale because you don't want to spend the money to go through the foreclosure process, make sure you know the statute and you know the law in that state. Because some states, after, doesn't make any sense to us, after the tax sale foreclosure is completed, some homeowners have the right to collect the overage, not the lender. So just kind of keep that in mind. We've also listed the states for judicial foreclosures, not only with the map, now we have them listed, and I'm not going to go over all of them. It's too many, it's just too many for me to just kind of read out loud. But again, our slides are available after the presentation, and they go up generally within a week after we're done.
Okay.
you really have to understand the process, you guys. And understanding the process will make life, so much easier. In the first part of the process, the lender files a lawsuit in the state, but they also have to have an attorney. I've not seen many lenders, unless they have in-house counsel, do their entire foreclosure. Even some of you guys are using an attorney, I won't name any names, as your workout specialist or your asset management person. He is not filing these foreclosures. He is actually hiring attorneys in the state that your asset is in to go through the foreclosure process. And I'm not trying to take business away from him, but I just need for you guys to understand, when you say that I have attorney X doing my workouts for me and he's handling my foreclosures, he's not licensed in all those states. Now, one lawyer that I will talk about is Damian Wallman. I'm not going to confirm if he's a good attorney or not a good attorney, but Damian has basically, he's become licensed in New York, New Jersey, Texas, Pennsylvania, and Florida, and maybe a couple other states. So he's still running a foreclosure mill shop and understand the process. And one attorney, even with the team, sometimes things get lost in the process. And when the lender files the lawsuit in court, you need certain things. You need to make sure that you've recorded your assignment. And if you haven't recorded your assignment, depending on if the foreclosure is already active when you buy the loan or not, sometimes it's better to have the law firm actually get your assignment recorded. And if the lawsuit has already been filed in the state court, make sure that you approve the $250 to $300 substitution of plaintiff fee, because if you don't, they're not going to substitute you in. Sometimes they'll complete the foreclosure in the previous note holder's name. And if you don't know how to kind of navigate through that, it makes it a little difficult. So once the lawsuit is filed, there's a couple of things that happens. They have to provide you notice. And there's certain ways that they provide you notice. They can have a carrier serve you at home, or they can run publication. Publication can run you a lot of money. And the reason why, publication has to take place sometimes. So when you're buying loans that is the estate of, or the borrower is deceased, or the co-borrower is deceased, and they can't get a hold of all the heirs, in order to get clear title, they have to run publication. And publication can cost a whole lot of money, into the thousands of dollars, depending on how many different places publication has to take place in.
Okay.
Documents that you need before you actually send your file to foreclosure, you need to make sure you have a copy of the note, a copy of the mortgage, a complete assignment chain, and a complete allonge chain. Right now, it's been 1 year on a note in Kentucky that we have been trying to get assignments recorded, and we haven't been able to get them recorded because the law firm just sucks. There's just no way for me to sugarcoat that. And we've gone round and round and round. So we're on our third law firm on trying to get assignments recorded. And now, dealing with the coronavirus, the recorder's office is closed. So now we still can't do it. So make sure that you know that you have a complete assignment chain, or also make sure if you have exceptions, if those exceptions are curable or not, if you want to move forward with foreclosure right away after you've purchased a loan.
Now, those attorneys that you're referring to, are those local attorneys in the area that the note resides, or does it matter? Are they just experts in the industry?
So initially we were using Casey Wilson and Associates to cure this particular case I'm talking about in Kentucky. Well, the law firm said that it would be easier if they cured the assignments, the assignment chain. And I really wish I had just left it with Casey Wilson and Associates, because as of today, I have to send those assignments back to Casey Wilson because a unit number was incorrect on one of the assignment chains. And you can't just cross it out. Now they're requiring us to correct the unit number on the assignment chain.
Michael Rogers says he lives in Lexington, Kentucky, and he says he knows a good attorney if you need one.
He can, and it's actually in Lexington, actually. So if he could just give us that information in our Q&A box, that would be great.
Yeah, perfect. All right, let's move on to the next slide.
So the timeline to complete a foreclosure in a judicial state, it could be months or it could be years. You know, when we hit the crash, certain counties in Ohio, such as Hamilton County, Cuyahoga County, it was taking 2 to 3 years to even just get on the docket to do your foreclosure. One of the other things that I want to also tell you guys is that anything that the law firm is doing on your behalf, make sure you get a copy of it. So they tell you that they're pulling title and they're charging you $350 or $500 for title. Make sure that you're getting a copy of that title, because basically if there's any delinquent taxes, there will be a red flag on the title report letting you know if you might have missed it during your due diligence. Sometimes if taxes have been sold, but there's a redemption period for taxes, make sure that you know that. The other thing is when they file something in court, when they file the complaint, get a copy of the complaint, keep the complaint. When they file the complaint, there's exhibits and everything that they're filing with that complaint. Make sure you have all of it.
Okay, I think that was our last slide, Saprina, and I think what we wanted to do here was we wanted to open it up for questions and answers, because we did get quite a few questions on this topic, and I know people out there have questions. Sometimes people don't ask questions because they don't know what to ask. So I'm gonna play devil's advocate here and kind of pretend that I'm a newbie and I don't know anything. Can you walk us through a judicial process from the time we know that we're going to go into foreclosure to when it forecloses?
So the process is again, depending on the state, there's a demand that's sent on behalf of you as the lender. So that's the first thing. So when you say you want to start foreclosure on a file, you actually, the law firm basically sends a demand and a right to cure the delinquency or the deficiency on the account. So normally that's anywhere from 30 days, 45 days, 90 days, depending on the state. Then in some states, there's also, there's another letter that will go out, and I'm drawing a blank on the name of that letter, but like in Pennsylvania, there is the Act 91 letter that goes out, and it basically, the next letter that goes out after the demand letter is basically giving them different places where they could actually go get help. If they could go get help from a HUD counseling center, different resolutions or solutions to secure the delinquency on their loan. And then the complaint is filed. I'm sorry?
And these are required by the jurisdiction?
By each state, by each state.
Right.
Some states require it, some states don't. Then you file the case in court. So that's the process of filing. And then basically it also gives you time, or the borrower time, to answer that complaint. Mm-hmm. Basically to say they didn't know their file was delinquent, if they, if there's a reason why that there should be something that the foreclosure should not be able to take place.
And if you don't get an answer from the borrower and you end up going to court, how does that look and what happens there? I mean, I'm assuming as long as you have adhered to the rules and you've sent out all of the information, the letters and whatnot, if you're not getting a response from them, you at least have covered that and you're in a better position when you go to court. Right.
Then you get the judge grants you you get a summary judgment, and then the sale date is set.
Right.
But also, you also have to, so let's talk about New Jersey. So this is something that I just learned recently about New Jersey. So there is, the homeowner has a right to 2 continuances, 30-day continuances on top of being able to request a mediation hearing. So people talk about how it takes so long to foreclose in New York and New Jersey. Those 2 states are very, very friendly to the consumer. So we had basically the day before foreclosure, we had worked out a modification or forbearance with the homeowner. She refused to sign, and then we got a notice from our attorney stating that she had filed for a 30-day extension. So that was in February. So then come March, she's engaging a couple of days before the next foreclosure date. And right the day before the foreclosure date in March, she got another 30-day continuance. So you can have up to 4 continuances in the state of New Jersey, 2 by the borrower, 2 by the lender, if you're working something out. So that prolongs your case even longer. And then if we go into mediation, those mediation hearings could take place every 30 to 45 days. Mind you, each one of those hearings, the attorney charges you about $250 to $300. So, you know, I just had an investor say, well, why do I have to participate in a mediation when my borrower is deceased? Well, the heirs still have rights, and they basically had deeded the property over before the borrower died. So because the borrower was deceased, but there was a new owner of record, even though it was a quitclaim deed, we still had to go through mediation with that particular homeowner because their name was on title. So I'm saying all of these things that can happen in the process. And then last but not least, after a foreclosure is completed in some states, such like as Michigan, foreclosure has been completed. You've submitted before the foreclosure is completed, you submitted your bidding instructions to the attorney on how you want to bid, and you get the property back. Bidding instructions allow you to win the property back. You get the property back, and there's a redemption period for the borrower. And those redemption periods could be anywhere from 90 days to 6 months. The only way you can shorten a redemption period is if you can prove that the property has been abandoned, meaning that it's been vacant, the utilities are off. You have to then go back into the court and show that there's no utilities on, there's been no activity, we've been cutting the grass, we've been doing this, we've been doing that. And if you can prove the property is abandoned, you can then shorten the redemption period, and you can get your sheriff's deed or your deed quicker if you do it that way.
And so what's the time frame then typically in judicial states? And I know that's a loaded question because it varies from state to state. But I think that one of the questions we always get is when you're doing your initial analysis and I come across judicial states, what should I be looking for from a time frame standpoint? Because you know, the non-judicial states tend to be quicker in the foreclosure process. So on the judicial side, knowing that that process could take longer, I mean, what are we looking at from a typical time frame? What is acceptable?
It could be a year and a half.
A year to year and a half on judicial?
On judicial, yeah.
So that's what they should be expecting then, a year to year.
That should be, and that's, you know, that's what they should be expecting. And if it goes over that, they really shouldn't be upset. Because again, you don't, when the paper that we're buying is not, you know, wrapped up with a pretty bow on it. So sometimes there's hiccups along the line. Sometimes you'll find that there's a certified copy of the note in the file. And then if you have to submit your file in your original collateral in the court, that could also create a problem with the court. If you don't have a clean payment history showing the true the true actual date of default, that could be a problem. So I'm telling you that it could be a year to a year and a half. That's in most states, but still New York, New Jersey, you're looking 2-3 years.
Right. Right. And
Pennsylvania is another one, you know, depending on the county in Pennsylvania, it's pretty slow. So you could be looking at still year and a half, and depending on where it is, because a lot of those small counties in Pennsylvania, the recorder's office, a lot of it is paper, a lot of it's not electronic. So you have to think about all of those things. Everybody isn't up on modern technology. Some of the rural areas are still really, really behind the times when you think about the foreclosure process and, you know, time stamping things and different things of that nature.
Mm-hmm. Keith said Michigan's redemption is 6 months and more than 3 acres. If it's more than 3 acres, it's 12 months. Yeah. So yeah, it's like we said, every state is different and has different time frames. I think so.
Michigan is really good on allowing you to shorten your redemption period if the property has been abandoned.
I was going to bring up the question related to understanding your exit strategy and whether or not it's profitable in some of these states that are judicial and are going to take anywhere from 1.5 to 2 years. Would the exit strategy be more geared towards reperforming notes rather than going through the foreclosure process? Because it seems to me that if you're purchasing assets at 50 to 55 cents on the dollar, it wouldn't pencil out at 1.5 to 2 years.
It depends on the spread that's left on the table. It depends on what you purchased at, and you said based off of what assets are selling for right now. Right. So I have an automatic calculator in my mind that if I'm buying something in a state that has a redemption period, I discount that note by anywhere from 15 to 25% of what market rate is. Or if I can find out where the foreclosure, where it is in the foreclosure, if it's close to the sale date, then I know that there's nothing, you know, strange going on with the case, then I say it still could be a home run. The other thing is that when you're looking at your exit strategies, you still got to look and see the occupancy status on the property, if it's vacant or if it's occupied. If it's vacant, there's no way you're going to turn that into a performing note. Very rarely do you ever find a homeowner that wants to move back in their house that they've abandoned for like 2 years and they left it a mess. So you have to make sure that there's a warm seat or there's a warm heart in that house if you want to be their saving grace and you want to turn it into a performing loan. Mm-hmm. So you have to think about that too. But if they're unwilling to work with you after you've sent a door knocker out there, maybe sent an agent out there, the likelihood of them turning that loan into a performing loan is next to none. I had a property in Michigan that I had done a foreclosure on, and they wouldn't talk to us. They wouldn't work with us. They put a cease and desist on the file, and a cease and desist is a do not contact. You're not legally allowed to contact them. And then once the foreclosure was over and the redemption period had expired, so we went all the way through foreclosure. We went all the way through the redemption, and here they come. Well, we want to stay in our house. We don't want to leave. And then when we got in the inside of it, I'm like, well, I don't want to sell it. I don't even want it. Stay, you know. But we ended up getting it on the market with a realtor. We were able to make a profit. But it was one of those things that the homeowner never came. They never surfaced until it was like they had waited out every single option they could wait out. And that type of homeowner makes me very reluctant to want to work with them. But once I got inside and seen that the property wasn't in that great a shape, then I thought about it. I got them in touch with a lender that I thought could get them a new loan where they could buy the property back. And it just didn't work. And so we agreed to give them a few $100s to exit the property, and they left, and we were able to get it sold within a couple of weeks.
And how many years delinquent do you look at some of these assets, and knowing that you might be able to reperform it? I mean, what's the threshold for you to say, you know, this thing's 4 years out or 6 years out, I don't even want to look at it because there's no chance for me reperforming it?
So I don't look at time. just so you guys know. So generally, I either have a BPO or I do an occupancy check, even when I'm doing large trades. When I know that I have an indicative bid approved, I will go out and I will do a door knock. And I say a door knock, but we never approach the property. I look at the emotional equity, and emotional equity tells me if they're taking care of their yard, if they're taking care of things. We had a property that I think it was 8 years delinquent, and we were able to get it to perform based off of the way they were taking care of the yard. That was the only thing that I looked at. And I never realized that they were 8 years past due when I did this. And this was in Pennsylvania. These people were packed. They had their stuff packed, ready to go, waiting for somebody to put them out. And we were able to get them into a plan because they were still paying their property taxes and they still had insurance. But because the loan had been sold so many times, they didn't know what to do, so they did nothing. So for me, it's not a matter of how delinquent the loan is for me to say, I don't want it. Other than, sometimes looking at the statute of limitations, and we're not going to talk about that today because I don't have enough time. But that's really what I look at. And my formula has not failed me yet.
We have a question here from Bruce. Bruce says, can you discuss what you can do legally, what you can or can't do with respect to direct communication with the homeowner during the foreclosure process?
So once we start foreclosure, so you don't ever want to get into dual tracking, basically trying to work with the homeowner and you also have active foreclosure going on. So that's why mediation is really important if you want to engage with them. But, we'll still send letters. We'll send cash for keys letters. We still send monthly statements. And if they call you and they want to negotiate, once we've received a hardship package, if they are wanting to stay, we will then put the foreclosure on hold, depending on where it is in the foreclosure. And if the hardship package is incomplete, we send them a letter telling them that it's incomplete. We give them a list of documents that they're missing. And if they don't return those in 7 days, we automatically send a denial letter. So we don't actually get into trouble with dual tracking. I hope that answers your question.
Yeah, Bruce, just let us know if that answered your question. Now, with respect to contacting them directly and verbally talking to them, how do you deal with that?
We still call on a regular basis. The only way we don't call is if they're in an active bankruptcy, if they're in a Chapter 7, we don't call, and then the foreclosure is put on hold anyways. But after the bankruptcy has been discharged or closed, we still send a monthly statement, but we do not call.
Okay.
So other than that, if they are not in an active bankruptcy or a discharge from a bankruptcy, we just continue our collection efforts on an everyday basis. They're still on the dialer. They're still in my asset manager's queue to work until we get to foreclosure sale.
And what are some of the indicators prior to foreclosure that would tell you that the borrower is thinking about bankruptcy or might go in that direction?
A lot of times they tell you. The other thing is their credit report. If everything, so we order a credit report every 90 days. And if we see great behavior change in that 90 days, meaning like they were paying their car payment, they were paying their credit cards, and then 90 days later they're paying nothing, that's an indication that they're going to file. Okay. And a lot of times they'll tell you, but there's a case right now. There's a note that I'm trying to buy in California. Contacted the note holder, someone in our network, and the borrower he's in an active 13, but I believe that the borrower wants to stay. And I think the type of payment that I can get on this loan, I would rather take the payment than the property. But so it just all depends. But this particular investor, because he's doing his own workouts, he's engaging with the borrower instead of the borrower's attorney, which I wouldn't do in an active 13. So again, you guys heard me say that if they're in an active 13 and they have counsel, do not engage with the borrower. You're putting yourself at risk.
Well, I think we're actually approaching, if not exceeded, our time limit here. Do we have time for a few questions, Saprina?
I have time.
Okay, so right now is a great time to ask those questions. You have the opportunity to get a direct answer from Saprina. We have quite a few people online now, so feel free to take this opportunity and ask, because I know that this is always a confusing topic for a lot of people in terms of process, in terms of what you need to look out for, how much it costs, how to incorporate it even into your bidding prices. So feel free to ask those questions. We'll give it a couple seconds here, and if nobody has any questions, we'll wrap it up. Does that sound fair, Saprina?
That's fair.
Okay. Looks like we've got about 43 people on right now. We had a question. Somebody's asking, Saprina, are you a servicer and who do you work for?
Yes, I am a servicing company. I'm not. I work for a servicing company, and I work for Mainstreet Asset Solutions out of Reno, Nevada.
If anybody wants her contact, just email me directly. I can give that to you. Or you can email Saprina. If you don't have her contact information, I can give that to you as well. And we'll make this available on the LOI site. So, you know, if you're looking for more information, you can go there, loievents.com. So we got a couple of questions here. Just popped out.
So one of the other things I want to talk about, one of the things that you guys also need to understand is that when the attorneys are asking you for bidding instructions, how you bid really can determine on if you get the asset back or not. So if you don't want the asset back, I would tell you to maybe make your bid about, I would say 20% less than the market value that you're finding online. But that's hard to do if you have, you know, if you've overpaid for the asset, you've overpaid in commissions for the asset, and your legal fees are kind of high. And also when you're doing your bidding instructions, you can factor in, they will tell you if you can, if the cost is recoverable on your attorney invoices. So when you're tracking that, just know that your invoices will tell you if it's a recoverable charge or not, and you can add that to your balance. The other thing is there are certain things that you can't charge back to the borrower, such as ordering credit reports or door knocks. You can't charge those back. But if you do an appraisal or BPO, that is a recoverable charge. The other recoverable charge is forced place insurance if you don't have proof of insurance. If you've advanced taxes, that's a recoverable expense. But I will also tell you guys, with the servicers, the auditors are coming down on us. And if you are advancing these fees on your own and you don't have backup to show that you've actually done that and you haven't provided it to the servicer, then it will not go on, on your account balance. If you don't have supporting documentation showing that you paid those fees. The other thing is when you're thinking about things that you can recover when you're getting ready to put your bid in on your asset, whether you're going to take it back or not, make sure that if you have 4 properties in one county and you're sending off a payment, make sure you send individual payments for each one of those properties with the map number or the parcel number, and that's your legal proof that you actually paid those taxes for that asset. The water gets a little muddy when you do one check, one county for 4 different assets. And I know some of us like to buy stuff in the same area, but those could hinder you on being able to include them in your bid when you're submitting your bid for your foreclosure process.
Hmm.
And generally the bid request comes anywhere from 2 months to 2 weeks away from the time that you are supposed to place your bid with the court. Sometimes they will ask for it by email. Sometimes they'll send you a form and you have to sign off to make sure that you acknowledge what you're bidding. If you don't get that form back, you might delay your process. Your attorney may say that they didn't have bidding instructions, and they'll basically cancel your sale date and set a new sale date. So make sure that you understand that when they're asking you that and they send you a form, send the form back, sign the form. When you have a servicer, you don't really have to worry about that so much, but a lot of you guys are using servicers that are doing your monthly statements, but are allowing you to do your own workouts. And basically, the servicer is not their responsibility to get that information back to the attorney. It's yours. So don't blame the servicer if your foreclosure gets set back because you didn't do what you were supposed to do. I have a rule that I don't really let anybody do their own workouts. We do everything for you, just because I know what people are doing and what they're saying versus not.
So we have a few questions, and I think there's like 4 questions, and then we'll wrap it up. First off, what states do you like? What are the best states for you to invest in?
So Ohio has been my sweet spot because, you know, that's my sweet hometown, Ohio. So Ohio is a sweet spot for me. I've had quite a bit of success in Alabama. I've also had success in Michigan. And I'm just referencing to the non-judicial states right now. Not non-judicial, I mean the judicial states. I do have non-judicial states that I have a few favorites in. Of course, we all love Texas. It's short and sweet. But those assets have become very, very expensive to buy in Texas. I love California, but generally only focus on seconds in California, not first. So those are kind of the places that I go to. But had a couple home runs last year in Kentucky that was very, very surprising, very surprising. When Granite was basically getting rid of the end of their portfolio, they had a few notes left in Kentucky, and their pricing was really right. So I got a couple home runs there. But you just really have to look at what you're buying. And for me, it's not the sweet spot in the state. It's about what the deal looks like and is it going to be profitable for me?
Right. And I think you bring up a good point, and really comes down to your purchase price. You make your money on your purchase price. Time is money. If you understand the time you have involved in it and how much you're going to be investing over that time frame, you'll understand your overall return and yields. And you know, having the right tools to do that obviously helps you. Most people here have already heard of the property analyzer that we've developed. If you guys want more information, you can email me directly, and I can even do a personal demo for you. But tools like that will definitely help you dial in your offer prices and understand whether or not you're going to make money on the deal. And the better you get at it, the more you're going to be able to, you know, isolate the best deals out of 50, for example. We do have another question here. What do you do if the borrower is willing to make a payment lower than the established contract amount and the lender agrees on the amount? Does the loan need to be modified?
So to protect all parties involved, if you don't do a true modification, you should at least do a forbearance agreement. We generally use a forbearance agreement because we don't have to have a loan originator sign off on that modification. And in some states, if you do a modification and you're not a licensed loan officer, you could get into trouble. The forbearance agreements are really, really simple. It states the delinquency, it states what the new terms are going to be. You also put in that agreement, you know, if they were to default, we basically revert back to the original terms, and we go back and we reverse the payments to the original terms if they go into default. But if they are wanting to make payment but can't afford what their original payment was, and you're thinking about turning this into a performing loan, the best way to do that is basically you're able, if you do a forbearance agreement, you're able to advance the due date based off the new terms. You season it if you don't plan on keeping it, and then you can sell it, at a 9-10% return to a passive investor for just cash flow. You've gotten your money back, you've gotten a couple payments, you recovered your expenses, and you can move on to your next asset, or you could just keep it.
We have another question. What, if any, state do you recommend to stay away from?
Well, again, I don't recommend you stay away from any state. It's about your risk tolerance and, just understanding the process in the states. I will tell you that, again, the challenging states for me has been New York, New Jersey, sometimes Pennsylvania. And the reason Pennsylvania is kind of an eyesore to me is because of the borough taxes, the school taxes, the city taxes, where if you miss something like that in your due diligence, there's all your profit. It's not even about the foreclosure process. It's about possibly missing something that could be huge.
Okay. Todd asked a question, why do you work in difficult states, or is it your servicing company and what comes in is what you work on? ?
So we don't turn any business away. So, I've been doing this for a very long time. No state scares me. It's just basically understanding, and I'm learning every day, you guys. I'm not going to tell you I know everything, but I'm not afraid to ask questions. I'm not afraid to roll up my sleeves, get my hands dirty in order to learn the process. So those states that that are challenging states, knowledge is power, and if I can actually be successful in a state that a lot of people are fearful of and want to stay away from, that's great. I will tell you guys, as much as I say New Jersey is really a challenge, when I managed a big portfolio, we made a ton of money in New Jersey. And the entire portfolio was New Jersey. It was upper end homes. And we played it right. We bought right. We made a ton of money on those loans. And there were even instances where, because the foreclosure was taking so long, where we actually had to put, we enforced our assignment of rent clause, had someone managing the rentals. It was huge. So again, don't look at something and say, oh, well, this tape is full of New York and New Jersey and I'm not going to buy it. Find out what the price point is before you turn your nose up to something and say, no, you don't want to do it.
Mm-hmm. We have one last question, and then we're going to have to wrap this up. But the question is what does Mainstreet charge for a performing note, servicing wise?
I think $30. I'm not on the pricing side. If you want a pricing sheet, I can get one over to you. Send me a message, send me your email address, and I'll get your pricing sheet over. Okay.
Well, fair enough. I just want to thank everybody for coming again today. We're going to have a follow-up on this webinar that we did today. Next week, it's going to be focused on judicial. And I think we might even take a look at the numbers and how to look at those numbers. I don't know if we're going to have time to get into that. Maybe we'll do a third one, but Saprina and I will get together and we'll try to figure out how to address some of that stuff. I can see a bunch of questions coming up right now, but unfortunately, I think we do have to go. And so with that, I just want to thank everybody. Thank you, Saprina, for coming. Thanks for your time. And we hope to see you guys next week on Thursday at noon. We got a bunch of thank yous.
Thanks a lot. Thanks for joining us. We'll see you next week. And with us being stuck in the house, some of us, maybe we will actually maybe just do a Q&A session for maybe 20, 30 minutes one day for lunch if we have time. And I depend on Joe for the technology. So I can't speak if this is something that we'll be able to do. But if we have some time, we may just, pop up just for Q&A and kind of freestyle it and not really have a subject.
Right. And, and I apologize if I didn't answer everybody's questions because I can see that there were quite a few in here. It's just we want to keep these things to a lunchtime time frame and not go over even though we went over a little bit today, because I know that this is a hot topic. But I will try to answer those questions offline. If you guys want to email me directly, you can email me at jking, K-I-N-G, at revivalbrothers.com, and I can answer those questions directly and share whatever you're asking with Saprina. Okay, with that, I just want to say you guys stay safe and be healthy.
Thank you. Bye-bye, you guys.